Will you
unredact
that? This? Will you
were
unredact
lead
this?
counsel on that. Privilege.
I'm asking you, will you unredact this?
If they're not privileged,
Quiet.
don't yell at me.
Your
if we review
improper
them and
redaction.
you'll like my answer.
To
if
continue
we review
to
them
protect.
And they're not privileged,
Representative Dan Goldman confronted Pam Bondi after reviewing unredacted Epstein files, revealing a hidden email between Epstein and Maxwell containing Trump's statements about their relationship. Goldman also proved DOJ deliberately exposed victim identities while protecting Trump's name, then asked survivors directly. Every single one had reached out to DOJ. Every single one was denied or ignored, yet all remained willing to testify.
Thank you, Mr. Chairman. Ms. Bondi, I went over to the department yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those 2 documents in unredacted form to members of Congress? Not a complicated question.
Well, I guess it is for you because you have a law degree and those are privileged.
Okay, they're not privileged, but we will discuss that later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead
this?
counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course. I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
If they're not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the clock? This is on your time. It's not on Mr. Goldman.
Even though you used your improper redaction,
you'll like my answer.
To continue to protect
Donald
time belongs to the member.
We'll be happy to release them.
We'll stop the clock. We'll stop the clock. Time belongs to the member. Go ahead.
Even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. 1 is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week—
How will you tell me that's intentional?
In an interview last week, Deputy Attorney General Todd Blanche—
You can't go off script.
—said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence? All of them. And of those of you, all of you who have reached out, how many of you were denied or ignored by the Department of Justice? All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses to talk to.
Gentleman's time has expired.
And I yield back.
Goldman began by noting he had spent several hours reviewing unredacted Epstein materials at the department the previous day. He immediately identified the absence of the client list Bondi had claimed was on her desk a year ago. What he did find was equally significant: an 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Epstein's co-conspirators, both still redacted even for members of Congress, in clear violation of the congressional bill requiring their release. When Goldman asked Bondi to commit to immediately providing these documents in unredacted form, her response was to claim privilege, a claim Goldman flatly rejected as legally incorrect. The most explosive discovery Goldman presented was an email from Jeffrey Epstein to Ghislaine Maxwell, unredacted, containing notes of statements Donald Trump made about his prior relationship with Epstein. Goldman was unequivocal. This document carries no privilege whatsoever. It is not attorney-client communication. It was sent between Epstein and Maxwell, neither of whom was Trump's attorney. There is no legal basis for its continued redaction. Yet Bondi repeatedly claimed privilege while visibly consulting with staff, suggesting she had no independent legal basis for the claim and was seeking political rather than legal guidance on how to respond. Goldman's analysis of the redaction pattern revealed deliberate and systematic misconduct. The congressional bill required one thing above all else: that survivor and victim identification information be redacted to protect their privacy and safety. Instead, Bondi's department did the opposite, protecting Trump and other powerful individuals associated with Epstein while exposing victims. Goldman presented specific evidence that this was intentional rather than accidental: an email titled Epstein Victim List, containing 32 names. 31 were left unredacted. 1 was redacted. Someone looked at this document, made a conscious decision about what to redact, and chose to protect 1 name while exposing 31 victims. Bondi's defense, that they had only 30 days to process millions of documents, was demolished by Goldman's revelation that the department actually used 75 days, not counting additional hours spent redacting materials the previous March. The timeline defense was not merely inadequate, but demonstrably false, further confirming that the exposure of victim identities resulted from deliberate choices rather than time pressure. The climax of Goldman's questioning came when he referenced Deputy Attorney General Todd Blanche's claim in a recent interview that any victim wanting to speak with the department had hopefully done so. Goldman then turned directly to the survivors present in the room, asking them to stand and respond to a series of questions. The results were unambiguous and devastating. How many survivors or their loved ones had actually met with the Department of Justice and provided testimony or evidence? None. How many had reached out, individually, through lawyers, or through representatives, to offer testimony and evidence? All of them. How many of those who reached out were denied or ignored by the Department of Justice? All of them. And despite the DOJ's shameful and despicable efforts to intimidate them, how many remained willing to speak to the Department of Justice? All of them. This 4-question sequence accomplished what hours of legal argument could not. It proved beyond any reasonable doubt that Blanche had lied, that the DOJ had systematically refused contact with the very victims it claimed to be protecting, and that these survivors possessed extraordinary courage in the face of institutional betrayal. They had endured Epstein's abuse. They had survived the DOJ's exposure of their identities. They had been ignored when they sought to cooperate. And still, every single one of them remained willing to help bring their abusers to justice. Goldman's final statement to Bondi was simple: "It looks like you have some witnesses." The understatement was devastating. The department that claimed to be working for victims had refused to meet with any of them. The department that claimed insufficient evidence had ignored every survivor willing to provide it. The department that claimed to be protecting victims had deliberately exposed their identities while hiding the email containing Trump's own statements about his Epstein relationship.